Hello, this is Georgia Attorney Drew Mosley continuing my review of OCGA 35-3-37. This is Criminal History Record Information, and I continue on here from two prior installments. This will be part 3. We left off last time with subsection G. We'll begin now with subsection H. This is access to an individual's criminal history record information, including any fingerprints or photographs of the individual taken in conjunction with the arrest, shall be restricted by the Center for the following types of dispositions. 1. Prior to indictment, accusation, or other charging instrument. A. The case was never referred for further prosecution to the proper prosecuting attorney by the attesting law enforcement agency, and I, the offense against such individual is closed by the arresting law enforcement agency. It shall be the duty of the head of the arresting law enforcement agency to notify the Center whenever a record is to be restricted pursuant to this division within 30 days of such decision. A copy of the notice shall be sent to the accused and the accused's attorney, if any, by mailing the same by first-class mail within 7 days of notifying the Center, or 2. The Center does not receive notice from the arresting law enforcement agency that the offense has been referred to the prosecuting attorney or transferred to another law enforcement or prosecutorial agency of this state, any other state, or a foreign nation, or any political subdivision thereof, for prosecution, and the following period of time has elapsed from the date of the arrest of such individual. I. If the offense is a misdemeanor or a misdemeanor of a high and aggravated nature, 2 years. II. If the offense is a felony other than a serious violent felony or a felony sexual offense specified in Code Section 17-3-2.1 involving a victim under 16 years of age, 4 years. Or III. If the offense is a serious violent felony or a felony sexual offense specified in Code Section 17-3-2.1 involving a victim under 16 years of age, 7 years. If the Center receives notice of the filing of an indictment subsequent to the restriction of a record pursuant to this division, the Center shall make such record available in accordance with Code Section 35-3-34 or 35-3-35. If the Center does not receive notice of a charging instrument within 30 days of the applicable time periods set forth in this division, such record shall be restricted by the Center for non-criminal justice purposes and shall be considered sealed. B. The case was referred to the prosecuting attorney but was later dismissed. C. The grand jury returned 2 no bills. Or D. The grand jury returned 1 no bill and the applicable time period set forth in Division 2 of subparagraph A of this paragraph has expired. And 2. After indictment or accusation. A. Except as provided in subsection I of this code section, all charges were dismissed or nolle prossed. B. The individual was sentenced in accordance with the provisions of subsection A or C of Code Section 16-13-2, and the individual successfully completed the terms and conditions of his or her probation. C. The individual pleaded guilty to or was found guilty of a violation of paragraph 2 or 3 of subsection A of Code Section 3-3-23 and was sentenced in accordance with the provisions of subsection C of Code Section 3-3-23.1, and the individual successfully completed the terms and conditions of his or her probation. D. The individual successfully completed a drug court treatment program, mental health treatment program, or veterans treatment program. the individual's case has been dismissed or null prost, and he or she has not been arrested during such program, excluding any arrest for a non-serious traffic offense. Or the individual was acquitted of all the charges by a judge or jury unless, within 10 days of the verdict, the prosecuting attorney demonstrates to the trial court through clear and convincing evidence that the harm otherwise resulting to the individual is clearly outweighed by the public interest in the criminal history record information being publicly available, because either the prosecuting attorney was barred from introducing material evidence against the individual on legal grounds, including without limitation the granting of a motion to suppress or motion in limine, or ii, the individual has been formally charged with the same or similar offense within the previous 5 years. I. After the filing of an indictment or accusation, an individual's criminal history record information shall not be restricted if 1. The charges were null prost or otherwise dismissed because a. of a plea agreement resulting in a conviction of the individual for an offense arising out of the same underlying transaction or occurrence as the conviction, b. the prosecuting attorney was barred from introducing material evidence against the individual on legal grounds, including, without limitation, the granting of a motion to suppress or motion in limine, c. the conduct which resulted in the arrest of the individual was part of a pattern of criminal activity which was prosecuted in another court of the state or a foreign nation, or d. the individual had diplomatic, consular, or similar immunity or inviolability from arrest or prosecution. 2. The charges were tried and some but not all of the charges resulted in an acquittal, or 3. The individual was acquitted of all charges, but it is later determined that the acquittal was the result of jury tampering or judicial misconduct. I'll continue on in another video.